Hi, my name is Janice Switlo, and I'm often referring to Indigenous law and long-standing, the oldest constitutions in the world. And I just want to quote from a book by Dr. Eben Alexander, and I agree with him. The ascendance of the scientific method, based solely in the physical realm over the past 400 years, presents a major problem. We have lost touch with the deep mystery at the center of existence. It was, under different names and expressed through different worldviews, something known well and held close by pre-modern religions. But it was lost to our secular Western culture as we became increasingly enamored with the power of modern science and technology. Now, this is a medical doctor. He's a neural surgeon. And he continues, for all of the successes of Western civilization, the world has paid a dear price in terms of the most crucial component of existence, our human spirit. The shadow side of high technology, modern warfare and thoughtless homicide and suicide, urban blight, ecological mayhem, cataclysm, climate change, polarization of economic resources is bad enough. Much worse, our focus on exponential progress in science and technology has left many of us relatively bereft in the realm of meaning and joy, and of knowing how our lives fit into the grand scheme of existence for all eternity. Now, appreciating Indigenous nations have been here for thousands of years, and what's always impressed me with their laws and their constitution is how well developed and how they were able to, long ago, resolve some of the critical issues that academics and others ponder, philosophers ponder. For example, wealth distribution, things like that, economic systems that work so well for their Indigenous nationals. Now, as we said, here's in that quote, was talking about how things progress differently in different parts of the world there. Now, Indigenous nations with their still existing constitutions, as I've said many times, becomes a problem because they still own their land, they still have the right to give consent or withhold consent, things of that nature. And it becomes problematic for a country like Canada because they don't want to live under those restraints. They want full control. They want whole sovereignty to vest in the Crown, so that under Crown constitutional monarchy, then those elected can control it all. That's just unfortunately not the way it is, and we're seeing the fallout from that as they try to manipulate that. And this is, I'm now quoting from Peter C. Newman, Canadian Revolution, and he's talking about the role of churches, if you will. And then let me just read this part because it's self-explanatory. Unlike most other social activists, the bishop didn't blame Brian Mulroney for this trend. Quote, he was a figurehead, and naturally we tend to scapegoat the idol who was raised on a pedestal and is suddenly cast down. What has happened to this country is disastrous, but I'm not willing to personalize it, end of quote. Other leaders of the mainstream churches were Archbishop Michael Piers, primate of the Anglican Church of Canada, a lanky and good-humored intellectual, could hardly contain his anger. Quote, I was primate for 7 of the Mulroney years, and all the church leaders together, all of us, Roman Catholic, United Church, and Anglican, right across the spectrum, never got to see him once. Not ever. We saw Perrin Beatty when he was in defense, because we may not have many divisions, but we're well connected around the world. And Tom Siddon in Indian Affairs, just after the Oka crisis, when the government was really in the glue. Our record with the Aboriginal isn't perfect, but it's long and committed, and they were desperate, end of quote. And so you'll see how, and that was 1990. In fact, I was in-house legal counsel of the Department of Indian Affairs at that point that he's referencing. So the not knowing what to do with Oka, Tom Siddon, Minister of Indian Affairs at the time, goes and speaks with church leaders, the religious. Why is that important? Well, where do you think the doctrine of discovery first comes from, right? So a plan is hatched. And then we look at who is the lawyer who's instrumental in furthering that plan. Marvin Storrow, 1990, the Sparrow decision, and he was also counsel in Delgamutte. And let me read this quote. What allowed Toronto to maintain such fiscal preeminence into the 1980s was its financial infrastructure, which could be reproduced in miniature but not completely duplicated in any other Canadian city. Even though the 4.2 million citizens in the Toronto commuter shed occupied an area of 5,600 square kilometers, the city's decision district was crammed into a dozen downtown blocks. 5 different colored skyscrapers, owned by Canada's 5 largest banks, dominated the skyline. It was the fountainhead of investment funds that financed everything from pipelines across the plains to a vaguely legal Screech distillery in St. John's. It was where the prestigious auditing firms did their painful things. It was where legal factories like Blake Castles or Goodman, Phillips and Weinberg could, in one shirt-sleeved weekend, put together a shopping mall in Red Deer or an offshore bank in the Bahamas. Anything was possible. It was the grand scale of its fiscal transactions, about $2 billion a day, that gave the city its national clout. Blake Castles, preeminent industry, business, law firm. Is it any wonder and why would Indigenous nations, well, it was Chief and Council, right? Indian Act Chief and Council, retained him to pursue their quote-unquote claims and put in place this Section 35 doctrine. That's talk about a perceived conflict. If all of your clients are these, putting together these billion-dollar deals, $2 billion a day, not that particular law firm, but it's the first one referenced. It's key. Everyone knows about Blake's, except Indians, right? Except Indigenous nationals. Apparently, maybe their chief and council it was suggested. Who knows, right? What Musqueam Band had in mind there when retaining him to do the Section 35 Aboriginal right case. Marvin Storrow, life bencher, Law Society of BC, in 1993 he was elected. His focus in his practice is Aboriginal rights and white-collar crime. He used to be a senior counsel with the Department of Justice for 4 years, 1971 to 75, and he was a partner in Blake's beginning in 1988. And as I said, he's pushing and critical to these Section 35 cases coming into being as a partner at Blake's. And again, partner at Blake's, Blake's being a preeminent industry and business law firm. So is it any wonder that the Section 35 doctrine went the way it went? Remember, religious leaders were consulted. We've got this doctrine of discovery. How are we going to keep that somehow in place? Section 35 doctrine comes up. It gets put in place through a cooperative Supreme Court of Canada justice. We have the preeminent business law firm. They're arguing it and putting it in place. So you can't expect the best interests of Indigenous nations to have been protected in those circumstances. You can expect, as I've been speaking about for some time now, you can expect them to create a new legal system whereby they can lawfully, in quotes, lawfully push aside the Indigenous nationals while denying the fact of Indigenous nationhood, so as denying the application of existing international law. And going one step further now, we have this effort to try to create new international law that says the correct and lawful way for UN member states to deal with these people is to contain them, that's a military term, to contain them within the domestic state, to preserve the UN member states' territorial integrity, and contain them within that. And that's all I have to say.